Let me see if I can find closing arguments here.
You may consider the following factors: how the witness looked, acted, and whether the witness appeared to you to be telling the truth when he or she testified. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that
Hold on, let me run this back a little bit.
The witness? Whether the witness was in a position to know about the matter to which he or she testified. In other words, how well...
Here we go. Billy said object to Becky's hearsay. That's funny. What are y'all voting so far? Most of you are saying he's guilty. I don't know. I haven't seen enough. Alan said the other guy didn't do it then. Well, I mean, he said, yeah, it was me. If you want to confess, hey, listen, if you want to confess to a murder, I will take that all day. No reasonable doubt here. If you want to take the punishment for somebody else, go ahead. That's on you, man. So are you saying that whatever the shooter said won't hold up? No, I'm not going to believe somebody who's trying to get a plea deal.
Your Honor, the defense rests.
Ladies and gentlemen, you have heard the proof in this matter. What you have had in your seats, is a jury charge. This is my portion of this trial. It's the law. Now, the law states that I have to read it to you. Please don't think I am insulting your intelligence by reading to you. I know you can read for yourself.
Can y'all hear okay? I never checked the sound.
You all have to hear it at the same time. Okay. That is your copy. Feel free to write on it. I have the official copy here that will go back with you to the jury room.
Yeah, rest in peace.
But feel free to make any notes that you'd like to make, and any changes that I have to make that I see that need to be made will be made on the official copy. Okay. State of Tennessee versus Justin Johnson. Members of the jury, the evidence in this case has been completed, and it is now my duty to instruct you as to the law.
It's low? All right, hold on.
After I instruct you as to the law, the state and the defense may present their closing arguments. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. Duties of the court and the jury. The law makes it the duty of the court to charge the jury the law relative to the case on trial, and the duty of the jury to carefully consider all of the evidence delivered to them in the trial and under the law given them by the court, render their verdicts with absolute impartiality. No sympathy or prejudice by the jury. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdicts. You must render your verdicts with absolute fairness and impartiality as you think justice and truth dictate. The indictment in this case is the formal written accusation charging the defendant with the crimes. It is not evidence against the defendant and does not create any inference of guilt. Statements and rulings of the court. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks which I have made do I mean to indicate any opinion as to the facts or as to what your verdicts should be. Statements and arguments of counsel. Statements, arguments, and remarks of attorneys are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made by the attorneys in this trial at any time that you believe are not supported by the evidence, you should disregard them. Along these lines, the opening and closing arguments of the attorneys are likewise not evidence. You must base your decision in this case on the evidence that was actually presented in this court, not on the statements of attorneys. Furthermore, the questions the lawyers ask the witnesses are not evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is true. Jury, judges of facts and law. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of this court. You should apply the law to the facts in deciding this case. You should consider all of the evidence in light of your own observations and experiences in life. Presumption of innocence. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial and is not overcome unless all the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty.
Say it again, Judge. Say it again.
And is not overcome unless all the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. Burden of proof. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. The state must have proven beyond a reasonable doubt all of the elements of the crime charged, and that it was committed before the finding and returning of the indictment in this case. Reasonable doubt.
Here we go.
Reasonable doubt is that doubt engendered by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt.
To let the mind rest easy as to the certainty of guilt. Y'all, I couldn't do it. As a juror, I couldn't do it. My mind would not rest easy. I'd be like, dang, you know, as I was saying to A in the chat, there's a lot of people that got out of the car when they pulled up to the house to get the med packs. What happened in between there? Dang, you know, I really can't see him. Say it again, Judge.
For the finding and returning of the indictment in this case. Reasonable doubt. Reasonable doubt is that doubt engendered by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element necessary to constitute the offense. Crimes charged and pleaded. The first count of the indictment charges the offense of conspiracy to commit first-degree murder. Embraced and included within the offense are the lesser included offenses: facilitation to wit, conspiracy to commit first-degree murder. The second count of the indictment charges the offense of first-degree murder. Embraced and included within the offense are the lesser included offenses of second-degree murder, facilitation to wit, first-degree murder, facilitation to wit, second-degree murder, voluntary manslaughter, aggravated assault, facilitation to wit, voluntary manslaughter, facilitation to wit, aggravated assault, simple assault.
That's a great point, John.
Facilitation to wit, simple assault. The third count of the indictment charges the offense convicted felon in possession of a firearm. The court will now explain to you the law applicable to count 1 in this indictment. Conspiracy to commit first-degree murder. Any person who conspires to commit an offense is guilty of a crime. For you to find the defendant guilty of conspiracy to commit first-degree murder, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant entered into an agreement with one or more people to commit the offense of first-degree murder. It is not necessary that the object of the agreement be attained. And that each of the parties to the conspiracy had the intent to commit the offense of first-degree murder, and that
Street
each party
justice is
acted
way
for the
better.
purpose of promoting or facilitating the commission of the offense of first-degree murder, agreed that one or more of them would engage in conduct which constitutes the offense of first-degree murder, and that one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is an act done by one of the parties to carry out the intent of the conspiracy, and it must be a step toward the execution of this conspiracy. Intent means that a person acts intentionally when it is the
I didn't put
person's
this on
conscious
there.
objective or desire to cause the death of the alleged victim. Conspiracy is a continuing course of conduct which terminates
too
when
fast.
the objectives of the conspiracy are completed, or the agreement that they be completed is abandoned by the person and by those with whom the person conspires. The objectives of the conspiracy include, but are not limited to, escape from the offense, distribution of the proceeds of the offense, and measures other than silence for concealing the crime or obstructing justice in relation to it. Abandonment of a conspiracy is presumed if neither the person nor anyone with whom the person conspired does any overt act in pursuance of the conspiracy during the applicable period of limitation.
Northside said, ClassE Dolph was a big figure. Oh, where is that sound coming from? That's something else playing? Oh, okay, it's this one. My bad. He said Dolph was a big figure. Pause.
Hey, yo.
They're going to find him guilty on the base of bias. If they don't, Memphis is going to burn down. They're going to riot, and the mayor and the powers that be don't want that. Well, the jury isn't from Memphis. Jury don't give up. And if y'all know how, what's the word I'm looking for? How tumultuous like interstate rivals are in Tennessee specifically. You'd be surprised. You go a couple counties over and they don't mess with other counties. So the jury is not from Memphis. So I guess that's something I should have mentioned earlier as well. So that's something for y'all to keep in mind.
If an individual abandons the agreement, the conspiracy is terminated as to that person only if and when the person, those with whom the person conspired of the abandonment, or the person informs law enforcement authorities of the existence of the conspiracy and of the person's participation therein. However, mere
Jurors
presence
from
is
Nashville.
not sufficient to support.
Nashvillians cannot stand people from Memphis. I'm gonna tell y'all right now. Sean said the jury's from Memphis. They don't give a fuck about Memphis. They don't care.
A conviction. Facilitation to wit conspiracy.
They don't care
to
nothing
commit
about no
first-degree
Dolph.
murder.
All they
Any
know is
person
Kenny
who commits the
Chesney
offense
and
of
Taylor
facilitation
Swift.
to wit conspiracy to commit first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential
I love
elements.
Nashville, man.
That the defendant knew that another
I love
person
Tennessee.
intended to commit the specific offense of conspiracy to commit first-degree murder, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense. And that the defendant furnished substantial assistance to that person in the commission of the conspiracy, and that the defendant furnished such assistance knowingly. Conspiracy to commit first-degree murder has been defined on page 4. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct
Yeah, we're
or
going
the
on 2 hours
circumstances, or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result.
All right, Judge, you're doing a great job of laying this out, but we want to hear closing arguments. Y'all know. Judge is like, hey, guys, this is what you need to consider. Make sure you look at this. Make sure this. All the evidence. You know, we spend a lot of money on this trial. Memphis ain't that big. Make sure you do the right thing. Here we go. The defense is up first. We are now 2 hours in on
Good
the
to see y'all
jury
again.
deliberating.
this is the last time you're going to have to hear from me. And as I see all of your faces, I know that's something you're looking forward to. And that's okay. I know that you all want to get back to your lives. And I can tell you on behalf of Mr. Johnson
she did a great job.
that your attention during this trial is greatly appreciated. What you've had to set aside in order to provide this service, I have no doubt that the court and Mr. Hagerman, Ms. Iris, all of us agree that you're indebted to you for that. Because like I said in opening, this is important. And you're about to have to roll up your sleeves and go to work. And it's going to be a difficult job. This young man's fate is in your hands. The concept of justice, right? We talked about that in Fort Dyer. We talked about that again in opening, right? And it's in your hands. Meting out justice. And it's difficult because what you've heard is the tragedy of someone losing their life, of their family members not having that person in their life. And that is terrible, and the court will tell you, as terrible as that is, you can't consider that when you're determining guilt or innocence in this case. But it's heavy. Now, on the other hand, you have Mr. Johnson. This young man that you heard in the evidence is a young man, aspiring rapper, wanted to make it as a rap artist. When you're going back through these exhibits, you're going to see a picture of him in front of the house on Bradley. Engaged in a music video, right, for his rap. Hat kicked to the side, kind of grin on his face, because that's what he wanted to do. And his fate is directly in your hands. And like we talked about, it's never justice to wrongfully convict someone. And so that determination that you're going to make, beyond a reasonable doubt, is the heaviest one, maybe one of the heaviest decisions you'll ever make. And you've had an opportunity to sit through the trial and hear the evidence, observe the witnesses, and you've been told, keep an open mind. And I hope you have. I'm sure you have.
Exactly.
And not to talk about the case. The thing that you've been listening to for days, with people all around you that are going through the same thing, and then you have to be around them even when you're not here, and you can't talk about the elephant in the room. But today that changes. And not only are you allowed to talk about it, the judge has instructed you that you have to talk about it. And to engage in deliberations meaningfully. To listen to one another. To review the evidence that you've heard. To talk about it. And render a decision. But to the degree you're working together, what you never have to do is abandon your conscience. Now, I don't mean conscience like Cornelius Smith and that conscience, right? Because I don't think he really meant that when you heard from him. He said, the reason I decided to tell the truth is I've got a conscience. And we all know that's not the type of thing you're dealing with. You take that more seriously. You mean it. He didn't. You've heard a lot of concepts, the terms of art and the law, the burden of proof, presumption of innocence. And when we started this, I told you, Mr. Johnson sits before you innocent. And I'm again telling you today, after the state has closed its proof, he remains that way. He didn't kill Adolph Ford Jr. He didn't conspire to kill Adolph Ford Jr. And he wasn't the man holding the pistol in the Makita video.
That's key.
And it's going to be up to you to decide that. To watch those videos. Watch them closely. They want to talk about those videos, and I'm encouraging you to study them. Give them a close look. The state doesn't want to acknowledge what I told you in opening, and that is similar. It doesn't mean the same. Plenty of people have gray sweatpants, black shoes with white soles, black hoodies. And as we learned through the proof, in Memphis especially, and elsewhere, Bass Pro has. You can look at it, if we had a window, you could look at it and you could see the Bass Pro, which is the pyramid here. You also heard testimony about it being a fad at that point in time. Famous rappers wearing it. Other famous artists. I think I mentioned Gwen Stefani wearing Bass Pro. One rapper has a signature Bass Pro hat. You heard from one of the detectives that they even interviewed someone who gave them a potential suspect.
Prosecution went first.
It wasn't Mr. Johnson, and said that person always wore a Bass Pro hat. You have to consider that. And then you have Sergeant Dabney, who, for the first time, and I think he acknowledged this, sitting on the stand, says, I think those underwear are the same. They're both blue. You look at the underwear from Tulane Apartments, you look back
Okay, gotcha.
at the Makita video, those are the same underwear. Look at it. Look at the steel shots. And for yourself, determine, can you tell if those are the same? And as jurors, you get to make that call. You get to look at it for yourself and compare those. We've heard a lot about it's not 1981 anymore.
Thank you,
And
Jenny D. You're right.
I agree.
I'll rewind it.
Right? You know, we've got cameras, but like I told you in opening, what also has advanced tremendously since 1981 is the world of forensics. Right? Fingerprints, DNA, touch DNA. And you have to ask yourself, why is Justin Johnson's DNA nowhere in that car? There's DNA in that car. You heard a lot about they wiped it. Cornelius Smith said he wiped it. And we'll get to whether you believe that or not in a minute. Okay? But he says he wiped it. But he didn't. There's fingerprints on it. Kristen Garner's, Trayon Ingram's, and Cornelius Smith.
Like I said, I changed my mind. Not guilty.
There was DNA found. One of it coming back to Trayon Ingram. Right? Not Justin Johnson. Now, there's a lot of talk about gloves. Right? They made a big point to say, you see gloves in the video. Now, they want you to believe that Mr. Johnson's running around in his Mercedes, and the reason his prints aren't on it are because he's wearing gloves. And mind you, Cornelius Smith, when he said he wiped the car, never said he wiped the driver's side of the car. Okay? If you believe that. And they want you to believe Mr. Johnson's driving around this white Mercedes, including with his daughter. Look at those videos. You think he's not wearing gloves, and he's got a little girl in tow that would presumably be in that car with him.
That's right.
No DNA recovered. None. Now, during proof, it was interesting because they would show the Mercedes go in the crosstown and the Mercedes leave crosstown, and they would show a video of Mr. Johnson getting out and walking in the building, or walking out of the building. There is no video that shows Mr. Johnson in that Mercedes.
None.
And you heard they had a reel, right? The video was a reel when they're doing crosstown, and when I asked it, I think it was Detective or Sergeant Dabney, about there was surely other cars going in and out this very time. And he said, yeah. But you have to ask yourself, was Justin Johnson ever in that Mercedes? So let's go to Kristen Garner. Kristen Garner gets up here and tries to tell you that. He tries to say he didn't know the car was stolen, that Trayon was driving around in the car. And at first, he acts like, even under questioning from Mr. Hagerman, that he wasn't even present when the car was exchanged, because he tries to say, well, Trayon told me. And if you recall, Mr. Hagerman had to kind of go back at him. I think he said something like, I can't tell you that. And then he eventually started answering some questions. You also remember that this is the same guy that went into law enforcement and said, I've never been in that car. I don't know a guy named Justin Johnson other than on Instagram. He's a rapper. And then suddenly, he starts evolving through the story. Still lying to law enforcement. He even looks at a video of himself, right, pumping gas, and goes, that's not me in the video. And he's like, okay, it's me. But they're trying to tell you Justin Johnson's at the Valero gas station, right? When he's pumping gas. Where is he? Now they want you to believe that this shadowy figure up in the right, top corner was Justin Johnson. And that he was the other passenger in the Infinity, but you can't really make out who he is. You have to rely on Kristen Garner. That's what you have to rely on. And we talked a little bit about, proof beyond a reasonable doubt. And I said one of the ways that you could use to kind of understand it is proof so convincing that you would not hesitate to rely upon it in making the most important decisions of your life. And it's really simple, right? You look there and you go, would I trust Kristen Gardner with anything? If he told me something, would I believe it? The answer is no. Because the more he talked, right, the more you realize he and Trayon are in the Mercedes. They're driving around with a Draco rifle, assault rifle. The same one described as being held by Cornelius Smith in the shooting of Adolph Ford Jr. Their prints are in the car. He says they have, he said a ton of guns in that car. And then he starts talking about how he's related to Dolph, and they were trying to dump the car before, right? And he's reaching out to Dolph's people to try to get rid of a car, which is the reason why after this happened, immediately, day after, he's calling Trayon going, my name's in this. My name's in this. Why would his name be here? And B, why couldn't he just say, oh, I have anything to do with this? And at Valero, you do see Trayon and Chris, they're there front and center. Now, there's been a lot of talk about the phone and location. And in the state's argument just now, you heard her saying what the expert said, with a phone using, a tower that could be, and he said could be, he said was in the service area of the Valero gas station, or then he said, I didn't do any drive testing, so I can't say what the coverage area would have been, right? And when you're looking at his slides, you've got that really thick PowerPoint exhibit, you'll be able to look at it. And you notice, right, that you're going to notice that the pictures are all really small, they're really zoomed in on the map. And he's talking about, like, this, do you think it's thorough? It's just thorough. I mean, he's going through all these calls. Look at what he's doing. I mean, but then you have to ask yourself, well, what happens if you expand the map? And then you realize, and this is the exhibit I entered, you realize he's not even counting all the data and calls, because when you show what he left out at 12:23, right, at the time, immediately after Adolph Ford Jr. was shot, there are several towers that Mr. Johnson's phone gets off of that are, one's 3 miles away in one direction, the other one is 3.2 miles away down by the Memphis airport. And then he has to go, I left those out. Not a really good explanation for why, right? Important. When there are a group of fine people that are looking to find the truth and have to make this decision and need to evaluate the accuracy of what he's telling you. And then you realize that when you talk about coverage areas and where things are in relation to these phones, somebody could be anywhere in a 3-mile radius, either any direction. And then you have to go, what is it? What does it show us? How did that help? How does that make you any more certain of someone's presumed location at a given point in time? Because he said it's not an exact science, and I'm not here to tell you that I can pinpoint where he is. And I didn't do drive testing, and I don't know. The next available tower is what a cell phone normally would look for, but also I can't even tell you if the towers were down at the time. That could make a difference. That could put you further out. I couldn't tell you if they were down for maintenance, if they were overburdened, and he said, look, if the tower's real busy, it'll direct you to the next tower. But what it doesn't establish is that Justin Johnson was involved in the conspiracy to kill Adolph Thornton. It doesn't establish that he killed Adolph Thornton or possessed a firearm.
I agree.
Now, a little bit about conspiracy and some more of the facts as you heard them from some of the other witnesses. Now, I have to take a little bit of an issue with the state on something that was said during their initial argument. And that is this. There was no evidence at all that Justin Johnson was present for any meetings
Ooh, great question.
discussing this hit. What Cornelius Smith said was he met with Hernandez Govan and Jook, and Justin Johnson was not there. And then he said he met with Hernandez Govan and others on another occasion to
They might
discuss
not
it.
have a verdict
And
today.
Justin Johnson was not there. So to suggest that he was present and agreed, where's the agreement?
I got you. Let's go. Thank you. Thank you for asking.
He wasn't there.
Amy is hurting right
Now-
now.
You get to Mr. Smith. The court has already instructed you about accomplice testimony and is already warning you that when you're considering that, you have to use caution. Now, you also have to apply the credibility factors that are in the jury instructions, but they're not an exhaustive list, right? Like we talked about in voir dire. Some of you, most of you, probably all of you have had to talk to somebody before and go, are they telling me the truth or not? And that's exactly what's here. But accomplice testimony is flagged because that person may have an interest in the outcome of this case. And you go, what is that interest? Well, Cornelius Smith, number one, told he had to admit, he didn't want to admit it, but he's meeting with the state. He's hoping to get a benefit on his own sentence. He's supposed to be telling the truth. But he's writing his sisters at the exact same time that he's meeting with the government, or the state rather, and telling them, I didn't do this, I'm just lying to get the deal. I'm just lying to get the deal. Now, is that his conscience, like he wanted to say? No. That's him telling his family. Why would he lie to his sisters? If he had a conscience, right? If he had done this out of the sense of, I did this awful thing, I feel awful, I've got to accept responsibility and tell the truth. No. But you remember, and it was kind of an interesting moment when he was testifying because
Yeah, maybe.
at one point he says, oh, that's not lying, I was gaming. Gaming's not lying. And the unfortunate part of all this is he's gaming everybody, including trying to game y'all. That's the problem. And he thinks he's going to walk. I mean, and the only person in this case who got paid for this. Remember, there is no proof whatsoever that Justin Johnson got a penny. Cornelius Smith got 50 grand for a lawyer for killing Adolph Thornton and didn't have to give it back.
And let's be clear, it's most likely that Cornelius Smith was the one who actually killed him. He was the one that started shooting first. Young Dolph was laying on the ground. Cornelius had the Draco.
He didn't have to give it back. His lawyer was in the courtroom.
Shout out to April.
And I asked him, I
baby
said,
daddy.
you remember, I said, how could you? You didn't give it back, you grew a conscience. What's going on with you? And he went, well, I did it. Service is rendered, right? And the lawyer, he's talking about with his sisters, he's saying, oh, well, my lawyer's telling me to cooperate. I'm walking. I'm not doing it unless I can walk. Now, he was asked by Mr. Hagerman, have I ever told you you're not going to have to go to prison? And he said, no, you haven't. But you have to keep in mind two things, right? At the time he was giving all this information that made him valuable to come in here and talk, he thought he was getting out. That's when those letters are going out. Those letters are going out, and he thinks he's getting out because he's got the lawyer, they got the cooperator from Ali Bobo to walk. And that's the type of thing you have to remember when you're assessing whether you can rely upon Cornelius Smith and anything that he said.
Yeah, and the only reason I bring it up, Phenomenal RN News blog, is that he took a plea deal. That's the only reason I'm bringing it.
The guy that sat in that chair, and he was asked by Mr. Hagerman, when you killed Adolph Thornton, what did you feel?
And he most likely got a reduced sentence to testify
And
against.
like it
Justin.
was nothing. Said, I didn't feel anything. Let's try to get paid.
Yeah, YouTube's been tripping, Mixed Chick. Thank you for being a member.
And that's the guy that they want to put in front of you and say, believe it. You know, he went and talked about exchanging money. Right? Getting $800. Right? At one point said, so you find people that he got that Mr. Johnson somehow came back into town and he talked on the phone with him and brought $500. And then some other time, some other guy in a Chrysler 300 showed up and provided money to his girlfriend. Well, two things. One, that's not what Mr. Smith originally said to law enforcement. He said that Chrysler 300 came twice, and then Mr. Justin Johnson wasn't anywhere in sight. Well, and what do you know about the Chrysler 300? Jamarcus Johnson. Right? Did Jamarcus Johnson say, when he was here in front of you, did you ever hear the state ask him, did you deliver the money? As part of you being involved in helping Mr. Johnson, did you deliver money for him? I mean, he asked about the email, or the text rather, about Cornelius emailing Justin's phone and saying, essentially, I need money for the birthday party. That's because Cornelius Smith is lying from start to finish. And then for the first time
It's
ever,
been 2.5 hours.
here in court, he says he wiped the card out. Who's in contact?
There you go, Glenn.
Who's in contact with Govan? According to Mr. Smith. Mr. Smith. Who's not in contact with Govan? Mr. Johnson. Did you hear anything about that?
Nope.
Now,
Take care, Steph.
when you go back in the jury room, you're going to be reviewing, obviously, these videos. And one of the things that you have to kind of ask yourself is timing. When you see Mr. Johnson in the elevator with his little girl leaving Crosstown that morning. And of course, you know there's going to be one exhibit that's the reel where the state had on it 11:51 in the morning. And then of course Mr. Hagerman came in, acknowledged the mistake to say that wasn't the right time. And put an officer on the stand, the lieutenant, to talk about getting access to the time, how he got the timestamp. But what that shows you is this. They don't know what time it was that day on that video. They don't know. I mean, mistakes get made. I'm not here to suggest that they don't. But you have to ask yourself, okay, the mistake got made, and then there's a timestamp. Okay, we want to put the timestamp one in. That seems like the logical choice. But then you have to listen to the lieutenant, right? And go, Lieutenant, what did you do to check and confirm that these were accurate times? Well, I looked at the live feed when I was in there. I had to have a technician, it's a computer, I don't understand it, but when I was there, I looked up at the screen and it appeared to be the right date and time. But not one person, you didn't hear from anybody that could say, that was confirmed, that's accurate, nothing happened with the system beforehand. And you even heard him say, it is not uncommon at all to pull surveillance cameras that have inaccurate date and times. Because you have to ask yourself about timing. You have to ask yourself about timing of leaving Crosstown, Mr. Johnson presumably going all the way to Whitehaven, if he's in that Mercedes and dropping his daughter off, right? And he said 20 minutes, something like that. Then he's supposedly driving all the way back to Wild Rose, 20 minutes, thereabouts, to pick up Cornelius Smith. They got to leave, then turn around and go to Bradley and go back to the white truck, right? And then get out and be in front of the Makita Cookie at 12:21. Now, that part of common sense and your everyday experiences, what does that tell you about going one place to the other, right? Takes longer, right? If you're stopping places, if you got to park, if you're presumably dropping a child off, there's going to be some kind of an exchange of a child, maybe a discussion with a person, and you build all that in. That's a lot of time.
It's a lot of time.
And I would submit to you that one of the reasons that became an issue is about correcting that time is when the state realized that I was asking questions of that witness and asking him how long it would take to get from point A to point B to here to here to here. Because when you do the math and it's 11:51, it doesn't work. It doesn't work. And all this about Bradley, even the exchange of the Mercedes for the Infiniti, the dropping of the Mercedes at Bradley and picking up the SUV, whether somebody cleaned the Mercedes or didn't, who moved their Mercedes to the backyard, all of that, according to Cornelius Smith, should have been captured on Hernandez Govan's home security system. Right? He said Govan had a security system directly facing Bradley because that's why when he decided that he was going to go wipe the car down.
Give me 1 second, y'all.
Either the day it happened or the day after, he couldn't quite remember. He texted Govan and said he was coming through there because he didn't want Govan to mistake him for somebody trying to come up on him. I asked Detective or Sergeant Dabney, did y'all canvass? Yes, we canvassed the neighborhood. He didn't do it personally, but he would have presumed they would have talked to everybody, including Hernandez Govan. Right? We don't necessarily know if they did or didn't, because we didn't get to hear from Mr. Govan. I asked Detective Browning if he was aware of any video from there. No. But if Cornelius Smith, right, is this person that's telling you the truth, because the truth doesn't change, then the fact that there were videos would have been known as early as March of 22, when he was meeting with law enforcement. And I'm not saying law enforcement doesn't want to find out who did this. They would have absolutely went and looked. But we don't know. We don't know. And there's a lot that you should know that you don't. Because there's a material witness that should have been called by the state that wasn't called. Hernandez Govan. And maybe some of you sat through this and thought, I want to hear what he has to say. And when I told you in the opening statement, I said, it's important, right, for you to weigh out and be able, as part of your duty as jurors, to be able to compare those two testimonies together. I'm sure some of you were thinking, yeah, that would make sense. I know we talked about that in voir dire, about getting two people to talk to kind of differentiate. Some of you that may have been a teacher, talking about that is one of the ways that you try to figure out who's telling the truth, who isn't. But you weren't able to do that. You weren't able to do that. You were deprived of that. And to be clear, as you heard about Hernandez Govan, he was cooperating in this investigation. He met with law enforcement on at least 2 occasions pursuant to a proffer agreement, which meant he was allowed to go in and give information and not have his words used against him later. I don't have the ability to make good on a proffer letter. Only the state does. I don't have the ability to wave a magic wand and give him a reduced sentence if he comes in and testifies for me. So he's to my exclusion. He's to Mr. Johnson's exclusion, and ultimately to your exclusion. And if this is a truth-seeking function, why didn't the state call him? And it is. Your job is to find the truth of the matter. And ultimately to go, did they prove their case or not? But you were deprived of that. And the judge instructed you about a jury instruction. And that's the law. That's part of all the different things she told you. This is as important as any of them. And the law states that it creates an inference that the testimony of that witness, Govan, would have been unfavorable to the state. Now, it's up to you to decide whether or not he was unavailable, a material witness, and whether or not there should be the inference. But you're allowed to make that inference in here. And unfavorable, I would tell you, unfavorable to the state means favorable to Mr. Johnson. And knowing that, can you really render a verdict of guilty and have your mind rest easy? And not walk away and go, I just don't know if I did the right thing. Knowing that there was information out there that could have been presented to you and wasn't.
He's cooking.
That would have been favorable to Mr. Johnson. That I couldn't give you. Can you be morally certain in that instance? In order to be convinced beyond a reasonable doubt that Mr. Johnson is the one in that Nikita video, you have to consider everything. You have to consider what you heard. And you have to go, what I heard from Kristen Garner and Cornelia Smith, was that so convincing that I wouldn't hesitate to rely upon it in making those most important decisions in your own life? Will my mind rest easy if I convict this young man based on their word in conjunction with that video and the other videos and what you didn't hear? The answer is no. When you examine your conscience out there, after you've taken the time to deliberate, I think you'll find the answer is no. 2 things I want you to remember, and I'm wrapping up.
Monica says, so Cornelia Smith took a plea deal for a reduced sentence and just chose some random dude as his accomplice. IDK, I'm on the fence. No, I don't think that's what anybody's saying. But also, is there proof to what he's saying? You have to think about that too. And they're not saying he's some random dude. They're just saying we don't know that he's the one, the second shooter.
The way the burden of proof works. And you've heard the statement, right? They ain't got nothing to prove. You may say that to somebody. I ain't got nothing to prove here. Justin Johnson, he doesn't have anything to prove here. They do. And we've all heard the term benefit of the doubt. Everybody likes to give somebody the benefit of the doubt. You are legally prohibited from giving the state the benefit of the doubt. You can't carry their water for them. again, I appreciate this is, as I said, the last time I get to speak to you. The state's going to get one more opportunity to talk to you this morning. They get the last word. That's how the system's set up. But it has been my honor to represent Mr. Johnson in this case, and it's been my honor to present this case before you all. And thank you so much.
Thank you, Mr. Chairman.
We started this with a little Memphis talk. Those cookies are fire. I think that's how we started it. A little more Memphis talk. What y'all even talking about? What y'all even talking about? A missing witness? Fernandez Govan? A missing witness? Fernandez Govan? Absent material witness. And the defense wants to say that is Hernandez Govan? What do we know about Hernandez Govan? He's a defendant in the case. He is charged with murder and conspiracy to murder. Whether it's from television or whether it's in black and white at the bottom of that same instruction, a defendant has the right not to testify and incriminate himself. He is a defendant. He is not a missing witness. That would be insane. I could willy-nilly just start calling every defendant. And they just have to come in here, testify. That's crazy. It doesn't even work like that on television. It doesn't even work like that in black and white in front of you. That would be insanity, and that wouldn't be a legal system where you had a Fifth Amendment right. That would be an inquisition, is actually what they used to call it, where you didn't have that right not to come in court. So the idea that the defense would call a defendant who's charged with this crime an absent witness shows you how desperate it is. And then we'll talk about things in isolation. Look at Kirsten Gardner. I'm sure he knew that car was stolen. I'm sure he did too. Well, then how can you believe him?
Thank
Or
you.
look at Cornelius Smith. I'm sure it's not his conscience that made him talk. I'm sure it's not either. He talked because he's caught. So don't believe him. Somebody made a mistake on one slide at the time, so it was corrected. So we can't believe video. You know, there's a word that actually exists because it's a thing. It's corroboration. It's corroboration is what they call it. Like, can you look at something somebody's saying and compare it to something else and then determine whether or not that person's telling the truth about it? Because that's how we should judge stuff. Did Kirsten Gardner know the car was stolen? I bet he did. Does he think Treon Ingram actually paid for it because of something? No, we didn't pay for the car. They're riding around with guns in a stolen car, and they're trading it with their buddy, Mr. Johnson. But how do we know that? Corroboration. Is there evidence that shows us that? Well, there's the Valero video, which shows something strange.
There's no evidence that shows that.
Kirsten come up in the car and somebody else get in and drive off. Strange. Another little piece of corroboration. Where's Justin Johnson's phone at the time? Well, in the area of the Valero station. Can you say it's in the parking lot? No, you can't. But it's in the Valero, in the vicinity of the Valero station. But my God, is there something else? Yeah. And this is what is ignored throughout the entire talk we just heard. We don't just have towers. We just don't have cell phone towers. We don't just have a Valero video. We just don't have a Haven Court video. We don't just have a Crosstown video. We don't just have a defendant who's like, Cornelius Smith, I'm guilty and so is he. That's us two in the parking lot shooting him. We got Justin Johnson's actual phone. We got his actual phone. In this case, it's been over so many times. Things that happen that are actually really dramatic just sort of happen. Because as soon as we saw the video of the Makeda shooting, as soon as you see the video of Crosstown of him leaving in the exact same outfit, in the white Mercedes, case is over. But we keep going. As soon as you hear from a codependent who's like, that's me in the parking lot shooting Dolph, I'm going to prison, and Justin Johnson's the guy next to me doing it, case is over.
No.
As soon as you see the Haven Court video, 40 minutes after the shooting, of the two shooters and his cousin, case is over. But then things kept on happening. That if you didn't have all that proof, would have even been more dramatic, or would have been dramatic. When they happened, I would see in your eyes a little thing, a little twinkle. We have his phone. And the night before, we have a text. The night before the homicide, we have a text. From who? Treon Ingram. To who? Justin Johnson. Sending him what? A picture of a white Mercedes. What do we have next? Another text. Justin Johnson. Treon Ingram. Dropping his location. Bradley. Gibson said they met on Bradley. Then they drove to Valera. And they switched cars. That's corroboration. So do you have to be willing to trust Kissing Gardner with the keys to your car? Of course not. You think I trust Kissing Gardner with the keys to my car? But do I know he's telling the truth about this? Well, yeah, I do. Because on video of Valera, it's documented in his phone with literal pictures and locations. This is plain as day. Do I have to believe that Cornelius Smith is talking because of pangs of conscience? No. No. He's talking because he got caught. Is he hoping that the truth will help him? Absolutely. He's hoping that the truth will help him. Is he going to prison after this? Absolutely. He's going to prison after this. Is there anything about his testimony
On a reduced
that we
sentence.
can corroborate? Oh my goodness. What's the first thing he tells us about that day? Justin Johnson calls me. I think I missed a call, and then I get a second one. And what do we got? Justin Johnson's phone. You can delete your call logs, which he did from that day, but they're still in the phone. And what do you know? 2 calls to Cornelius Smith from him right before he comes and picks him up at Lamar says. That's corroboration. What does Smith tell us? We go to Bradley directly after the shooting, but dump the cars. Dump the cars is important. Because here's another little, real tricky truth test. Justin's driving the white Mercedes. You see the video, of course. Cornelius testifies to it. He says, we drive to Bradley. He hands me the keys to the Expedition. I jump out of the car. I get in the Expedition driving while Justin parks the car in the driveway there on the front. Well, we know the white Expedition is also Justin's car. We're saying it across town for testimony. What do we see at Haven Court? Cornelius says, from there we end up going to Justin's cousin's apartment. It used to be called 2 Lanes, Gospel Gardens, the address on Haven Court. We see the white Expedition arrive. And who's driving? The white Expedition. Justin's car. Who's driving? The dude with the messed up shoulder and the messed up shirt. Cornelius Smith. I mean, how do you make that up? How do you make that up? They pull up at Haven Court with Cornelius Smith driving and Justin in the passenger seat, just like it had to happen, just like Cornelius Smith told you when he testified. We do the shooting. Justin's driving the white Mercedes. He hands me the keys to the Expedition. He gives Bradley. I jump out. I get in the driver's seat of the Expedition. Justin parks the Mercedes, jumps in, Haven Court. And what do you know? That's what we see. And what do you know? If you're lying, that detail is almost impossible to account for. Corroboration. We plainly see in the video, Haven Court. We plainly see them go inside. We plainly see Justin Johnson come out, meet this character in the Dodge Challenger, get some other clothes, get some bags, go in. We plainly see the Chevy Trax come, Angela Arnold, pick up Cornelius. We plainly see Justin get in his car, the Expedition, and the 2 pull out.
It's not
his
a crime.
Is corroborated over and over and over. And that's so incredibly important as we do trials. That's how we make decisions. Corroboration. That's why we have evidence. That's why we don't just call one witness and say it's over with. We put evidence in front of you. And one of those moments, when this trial was just over again for the 5th time, was when we were showing the slide from his phone, from Justin's phone. Cornelius says right after the shooting, Justin calls and FaceTimes with somebody. He says it's a big joke. The guy that put the money down for this. Number 2 is CMG. The guy that put hits on the other artist too. Cornelius says, FaceTime. Spelling out Dolph with your hands. And what do we find at Justin's time? I mean, delete stuff all day long. He did. Whole day. November 17th. Deleted all day long, but it's still in there. a call and FaceTime interaction with him. Justin Johnson with Big Joe. What they do? Cornelius tells you. And there you see it in black and white. It's not 1981, no, that's true. Called on camera and everything else, but you're also walking around your pocket with a phone that you can delete a call log, but it's still there. The times you called Cornelius Smith that morning, still there. The time when you called and then FaceTime with Big Joe right after the murder of Dolph, still there. The videos from Haven Court that show you arriving, still there. The videos of Haven Court that see you changing clothes. Did he have enough time to do it? Yeah, he had enough time to do it. He left Crosstown at 10:51. He had over an hour and a half to go drop off his kid 20 minutes away and drive 10 minutes. Total trip probably take you 30 or 40 minutes. Yeah, you have enough time to do it. We saw him do it. Memphis talk? All the times. All times. Before the murder, we see him at Crosstown. New murder outfit. Similar clothing? No. Identical clothing. Patch on the legs. That's pro hat. Everything. Before the murder. The Mercedes. Similar Mercedes? No. Back end damage, just like we saw in the video. During the murder? Again, caught up on video. White Mercedes, back end damage. The exact same clothing across town. Looks like him. Right-handed like him. Gloved up, like Cornelius said. Driving away from the murder. Who you call it? Who you texting? Big Joe. Caught before. Caught during. And then caught after. At Haven Court. Video of them arriving and leaving. Caught before, during, and after. That's called being caught all the times. All the times. He's literally caught before, during, and after. Caught all the times. And then what does he do? Then what do we have? Another Memphis phrase. Get on down. Get on down. Cross town the last video. Packing my suitcases to head out of town. Packing my suitcases to head out of town and get on down.
Yeah.
Like the police tell us, a manhunt. Not just in Memphis, well beyond Memphis. As Jamarcus tells us, he's going in and out of town. As Jamarcus tells us, he sees pictures on social media, Rolls Royce, stacks of money. Get out of town, get on down. The crime has been committed, Dolph has been killed, and we literally see him at the elevator with his suitcases getting on down. Flight can create an inference of guilt? Well, yeah. Well, yeah. This case was over when you saw the videos. This case was over when you heard from the co-defendant. This case was over when you saw him at Crosstown with the suitcases leaving, knowing that the manhunt was coming, and he was out of town and leaving. Really. Really. Now it's time for us, though. Now it's time for us to get on down, but we don't get on down by fleeing. We don't get on down by hiding. We don't get on down with pictures of Rolls Royces and stacks of money. We get on down by doing what's right and doing our jobs and looking at the evidence, the witnesses, the corroboration, and applying the law to those things. We get on down by doing justice. We get on down by saying you are called all the times. You are called all the times and you're guilty of all the things. Conspiracy to commit murder? I just heard, okay, let's at least cut him a break on the conspiracy to commit murder because man, he wasn't there for at least like one of these meetings with Big Joe or something. That's what I just heard. Let's cut him a little break on the conspiracy to murder because he's not at this meeting with Big Joe and Govan and Cornelius. So let's cut a little break on that. That's what I heard. Let's cut a little break on that. There's no requirement in the law that every conspirator have to be at every single meeting with each other. There has to be an agreement, an understanding. And there was clearly an understanding. Big Joe is going to pay money to take out PRE artists, and at the top of that chain is Dolph. Now, does he demonstrate any understanding of that? Is there anything he does that shows he's part of this understanding that this is going to happen? Yeah. He literally shows up with gloves and guns, has a white Mercedes he gets from Treon, has Cornelius driving next to him, and they drive and go do it. So the idea that, okay, he committed the murder, but give him a break, no. He's guilty of the conspiracy, just like they're all guilty of the conspiracy. And of course he's guilty of the murder because we watched it on video. Last, short thing. Just one minute. Just one minute. You two real. Dolph, you two real. He rapped about what he calls come on. What he saw in the evidence, what he saw in his family. Growing up. Two real. He rapped about people that he had a rivalry with. Too real. Dolph, too real. He included disses with dangerous people, like Big Joe. You're too real. Too real.
Still no jury yet, y'all.
Too real. Last moments of his life, last seconds of his life. How long was the videotape? 30 seconds? Too real. Dies on the floor in the neighborhood cookie store in Orange Mountain. Too real. Too real. Your family misses you. Erica and Mia and the kids. You too real. This is real. This is too real. And when the killer, one of the two, is caught on video, all the times, we even watch it get on down, it's time for us to be real. And we don't need Memphis off for that. It's called just do what's right. It's as simple as that. Just do what's right.
We might not get a verdict today.
Justin Johnson killed Adolph Gordon Jr. November 17th. We watched it happen. Eddie Smith, Justin Johnson, Hernandez, Govan, Big Joe, they all conspired to have it done. And then it was done. November 17th, 2021. And as he did, he was already a convicted felon. He should be found guilty of all counts. We do what's right. That's how we do. Guilty of conspiracy to commit murder, murder in the first degree, and convicted felon in possession of a handgun.
I got a few more pages of the charge to read to you. I'm going to pick up on page 29.
Okay, there it is. Excellent job by the prosecution. I think they lay it out.